I'm here on Miss Gill. She's set for a bond today, and
She in
so
custody?
she is. Yes, Your Honor. And she has one pending felony, but she's out. She already has she's out on a bond for that one already. She just has no bond set in this case.
I see bond sets. I see the FSGI is at 1,000. Yeah,
Okay. I talked
it must
to,
have just gotten set. I don't know.
okay. Is it a PR bond?
No, it's a
Okay.
sheriff.
Okay, then if we could review it today, is that possible?
Absolutely. Do
Okay.
you mind, Deputy Etchigoin, do you need a translator?
No.
Do you mind me bringing up Miss Gill? All right. Good morning, Miss Gill.
Good morning, Your Honor.
I wanted to bring you out because we're talking about you, and it's only fair that you get to hear what's transpiring since these are your cases.
Yes, sir.
I want you to know, I don't know anything about your case. All I know is that you've now, as of 3/26, yesterday, you picked up a failure to stop and give information. What happened? Or, well, hold on. You have the right to remain silent. Anything you say can or will be used against you. Okay.
On March 25th, 2025, officers were dispatched to 15357 Wallaceville Road in Harris County, Texas, regarding an FSGI call. Upon arrival, the officer spoke with the complainant, who stated that she followed the defendant after the defendant's vehicle hit her twice and failed to stop and give information. The complainant stated that she was driving southbound on the East Sam Houston Parkway, and the defendant failed to drive in her lane and sideswiped her, causing the vehicle damage to the right side panel of the defendant's vehicle. The complainant stated that she blew her horn several times for the defendant to stop, and the defendant refused. The complainant followed for approximately 3 miles to 15242 Wallaceville Road, and the complainant and the defendant exited their vehicle, and the complainant told the defendant that she hit her vehicle and needed insurance information. The defendant then told the complainant no, and that she was getting something to eat. The defendant went inside the business, exited, and then entered her vehicle and attempted to drive away. The complainant blew her horn several times to get the defendant to stop and told her the police were coming, but the defendant ignored the complainant. The defendant then began to put her vehicle in reverse and proceed backwards, hitting the complainant's vehicle a second time. The
So
complainant.
are you telling me that now it was intentional?
The complainant moved her vehicle to avoid being hit and followed the defendant. The complainant flagged the police down to identify the defendant as the person who struck her vehicle. The estimated damage from the complainant was around $4,000, and the defendant stated she didn't stop because she was hungry and colored.
And what?
Colored.
Color.
Yes, Your Honor.
Can you look up to see if she has a valid Texas driver license?
Yes.
Ms. Gill, I'm going to find that there is sufficient probable cause to go forward with your case. Not only are you on a felony probation for assault of a peace officer, not only are you on felony probation for injury to a child under 15, but you pick up, after both of those, an evading arrest of your vehicle, and now an FSGI. I am taking away your privilege to drive. You will now be signing an affidavit with me today, promising me you're not going to drive. I don't give a rat's behind what your excuse is. If I find that you drive in violation of this affidavit, I will have a contempt. I can have a contempt hearing. I can have a contempt.
After.
Finish.
I'm so sorry.
Finish.
I'm a commercial driver.
Really?
Yes.
Really?
Yes.
You, if you do have a CDL,
Sorry, that is correct. She does have a valid CDL.
are held to an even higher standard because of that CDL. You now have a total of 4 open cases, one of those being this FSGI and an evading arrest in a motor vehicle. I am taking away your privilege to drive. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine. I truly am at a loss with the attitude.
Okay.
Truly.
Okay.
This case here, not only do we have an FSGI, but it's also alleged that you backed up and hit the person intentionally. Because allegedly hungry and covered. So now this is an affidavit, and I hope that you take it seriously, because if you don't, there will truly be disastrous consequences. Ms. Gill, I want you to understand that I'm going to do everything in my power to protect my public at all costs. Do you understand?
I understand you, Your Honor.
May I make argument for a PR bond, Your Honor? She's made a bond in the felony already. And even with the affidavit to not drive, I expressed to her that that was a possibility of a bond condition. I've spoken with her. She has family members who can help her get to and from court. She's a single mother of 2 children. She has lived at this address here in Houston for the past 5 years. She lives with her mother. She lives with her younger brother. Has lived in Harris County her entire life. And she has, in these felonies, she's actually applied to be put in mental health court because during this incident and the felonies, she was unmedicated and she has a history of mental health diagnoses. And so as a client of the Harris County Public Defender's Office, we have every intention of getting her treatment for those mental health issues. But she's already made a bond in the felony, and she is willing to abide by any condition that this court will impose on her. It's down to the difference between $0 and $100. And
So I appreciate your argument. She's technically, you are right on bond. My feeling is that these felony courts probably do not know that she has now picked up this case yet. So I don't know what, if anything, they're going to do when they do discover this. I find, Ms. Goucher, right? Is that what Ms. Goucher? I really appreciate your argument going to bat for her, but I think with her demeanor, her attitude, her reckless and wanton action on the road, is that you are a danger to the public, and your bond is now set at 1,000, and I'm going to raise it to 5 because I think that you really are a danger to the public, and your attitude shows us and tells me that, hey, I'm going to do what I want to do, and that's it. And that's always, I mean, really,
don't say it.
how many people died this weekend on the road because of the reckless and wanton actions? All we want are our streets to be safe.
You're not helping me, Your Honor. You're not helping
Don't
me.
say anything.
I'm struggling. I'm a single mom, and I've been struggling with the courts for years already, and I'm tired of this. Okay? I was beat, okay, in front of my children, and I was thrown on the ground like an animal, okay? And I'm tired of this. I'm tired of all of this, okay? In front of my children. My children have trauma, okay? And I have no insurance for the medication, and I've not been on the medication. I'm trying to get the insurance to get on the medication.
Ms. Gill,
Okay.
I understand that, but at some point, your actions become your own,
You
right?
don't understand. I'm colored. You don't understand me. You don't understand me. If I was a different color, you would. And it's true.
That's so
It's
not.
so true. It's so true. And you know this. You know what I'm talking about.
I call out discrimination when I see it on a daily basis, ma'am. I don't care who it is. I don't care what color. If they're a small farm animal, I don't care. I call it when I see it. The only thing, because I don't know them. The way I get to know them is paper. And they tell me what happens in the case. And from what I see here and what has transpired here within the last 10 minutes, really?
Officer Harris did not read me my rights.
Okay, well, I will let,
They've been mishandling me like this for years already, okay? I have the right to tell you this. And I'm telling you, she did not read me my rights. She just shoved me behind the officer car. I did not get a voice to speak out anything.
yes,
She just brought me to jail.
you guys speak about that. I'll tell you, look, here's what I'm gonna do. I'm gonna leave your bond at $1,000 now, all right? I'm not gonna raise it to 5, but I can't continue to give you a PR bond.
Terminated from employment too.
Listen,
Okay.
do not drive. That's the only thing I'm asking you to do.
I'm a commercial driver.
Don't pick up a new
Yes,
case
sir. Yes, sir.
and just, all right. Come on. Justin, I didn't want you to leave because I know you've been waiting.
Oh, no. I heard here, his appearance, was required today. We submitted the mitigation packet. I just submitted it. I've been waiting to hear back from Blaze on some things.
22 and 23.
So, all right,
But he said, go ahead. I showed him what we had. He said, go ahead and send that. He's still gonna have the conversation with those guys about the other
so
things.
you haven't sent it then?
No, I've sent it. He should have. Yep, I sent it to all the appropriate people.
So we'll give you a couple weeks. I'll waive it for the next one because we're just gonna get a response, okay? If he's approved, then
I'll
he's gotta be
running
here. So we can do a
Okay.
TRAS. Okay?
Oh, right.
So if it's not approved by the next 2 weeks and it's still in limbo.
I'll let you know. Okay.
The only reason we'd have him come is so we can start moving, right? So if it's approved, then we need him here so we can do a
Are you
TRAS.
able to do like a T-Raz that day, like a walk-in?
Yes,
Okay.
we'll send him and do a walkthrough. Well, that's why we have him come so we can just get it right done.
Yeah, no, it's a hardship for.
Pick a day, 2 weeks, and then waive it.
Gotcha.
It's not it's
In limbo.
still pending.
Yep,
If it's no, or if it's yes, then he's gotta be here.
gotcha.
Okay,
Okay, thank you, Judge.
have fun.
Here on Mr. Jermaine Mallard.
Is it Mallard?
Yes, sir. I wanted to approach about his bond conditions to see if we can get those amended. Currently, he's required to do the random drug and alcohol test. He has a GPS monitoring with the curfew from 9 to 6, and he has a SCRAM device. I wanted to see if he could get the GPS monitor removed and have the curfew removed. He does work. His work hours are from 6 a.m. to 6 p.m., sometimes 8 p.m., depending on the day. But he also needs time to travel to and from work. He also supports 4 kids.
Time do you want?
I'm sorry.
What time do you want again?
I was asking for it to be removed.
I mean, it's a DWI second. It's got, I need to do a deeper dive. So if you want to give me a second, we can talk further, but I've got a waiver real quick. Let me help him out and then I can do a deeper dive. I put it on there for a reason. It's only been, not even 2 weeks. So let me do a deeper dive to see why, because I don't remember.
Yes, sir.
I don't remember anything about the case. So if you don't mind, please.
On March 1st, 2025, at approximately at 11 p.m., the officers were dispatched to a 911 call regarding a motor vehicle stopped on the road with a male in the driver's seat passed out at the 300 block of North 8th Street in Harrisburg, Texas. The officer observed the defendant's motor vehicle stopped on the road facing the wrong side, forcing multiple motor vehicles to drive around the defendant. The officer observed the defendant's engine on, with the defendant sitting in the driver's seat, appearing to be sleeping or passed out, with the motor vehicle in drive and the defendant's foot on the brake. The officer observed an open container of.
Come up, Mr. Mallard. Just kind of rewind about
Sure.
3 sentences, please, when he's up here.
All right. Officer observed the defendant's motor vehicle stopped on the road facing the wrong side, forcing the motor.
Going the wrong way down the street.
Stopped on going the wrong way, yes. Forcing multiple motor vehicles to drive around the defendant. The officer observed the defendant's motor vehicle to be on, with the defendant sitting in the driver's seat, appeared to be sleeping or passed out. The motor vehicle was in drive with the defendant's foot on the brake. The officer observed an open container of Bacardi rum, a 750 milliliter bottle, approximately 10% full, sitting in the front right passenger seat. The officer attempted to wake the defendant unsuccessfully, which led to the officers being forced to break the defendant's front right window to get into the motor vehicle due to the doors being locked. The officer placed the motor vehicle in the park, and the defendant was asked to step out, and he immediately fell to the ground. The officer observed slurred speech, red bloodshot eyes, a strong odor of an alcoholic beverage, and poor balance. The defendant refused SFSTs. The defendant advised that he had not consumed any alcohol beverages and wished to speak to ask for his lawyer, and was loudly repeating no comment to all questions. The defendant was read the DIC, and he refused breath, and a blood warrant was signed. The defendant was transported to HCA Southeast ER to obtain the blood, and the defendant
I think I'm good.
Your Honor, this gets into the resisting,
Oh, okay.
which I understand if you
That's okay.
but it is. So the officer the defendant refused to exit the vehicle, even though the officer was asked to multiple times. The officer had to physically guide the defendant out. The defendant stopped walking while walking to the emergency room with the officer and advised that he wanted to go to the VA hospital. The officer advised the defendant that he had a search warrant, and the defendant refused to move. The officer grabbed the defendant's upper arm and again advised the defendant of the search warrant, and again he refused to move. The officer then advised the defendant that if he had to pull him inside, that he'd face additional charges. Again, the defendant refused to move. The defendant advised he wanted to go to the VA hospital and tried pulling away into the direction to the entrance of the hospital. The defendant went dead weight and laid on the ground outside and refused to move and screaming at the top of his lungs, "Someone help me." The officers had to be assisted by hospital security and placing the defendant into a wheelchair and transport him to the hospital, and blood was drawn with the assistance of 3 officers holding the defendant down.
Mr. Mallard, do you watch the news?
Yes, sir.
How many people died this weekend due to an alcohol-related collision?
The one that comes to mind, sir, is the softball team. Her mom, her dad passed. Is in critical condition right now. That's the latest one that I did see, sir.
There were at least 3, if not 4, different accidents this weekend where people died. There was in Galveston an entire family that was cut down because of an alcohol-related collision of a person who allegedly just completed a DWI intervention course here, and a couple months later goes out and then decimates an entire family. In this here now, you pled to a DWI not 3 months ago with above a 0.15. Now you hear on another one, there's alcohol allegedly in the car, the wrong way on the street, completely passed out to where. There is a reason why I do things in life. I don't do it just for shice and giggles. I want to protect my community at all cost. And I think that it is an appropriate condition to not have you near the car. Do you understand?
Yes, sir.
All I care about in this short life is protecting my community. And I'm going to try to do it at all costs. I understand that it may be a hardship to you, but sometimes in life, things are learned when they're faced with difficulty. And now I do not want you out in the middle of the night, and I don't want you near a car. Do you understand?
Yes, sir.
Perhaps in some time, because I'm not an a-hole. I try not to be, right? But it's been 2 weeks since you've picked up this DWI. I shudder to think, do you have the blood back yet?
No, I did not have to get back yet.
Before anything, even remotely getting near, I want to see some proactivity on your part.
Yes, sir.
But you coming up here and saying, woe is me, goes in one ear, goes out the other ear. I care about my community. That's what I care about. That's what matters most to me. And I'm going to protect it at all costs. You understand?
Yes, sir.
So I am willing to work with you on the hours if you need hours to work, but I don't want you out in the middle of the night. Do you understand?
Yes, sir.
Okay, thanks.
Yes. Thank you, Your Honor.
Please.
And just to let you know, he has started attending AA meetings. He's been attending for the past couple of weeks every night, virtually. One of the facilities that offer the AA meetings, they do offer it, is it at 10?
It's at 9:30.
At 9:30. But his curfew would need to be extended a little bit more at 2.
You can do it at all times during the day. You can do it remotely. You can do it via Zoom. You can do it online. I don't want you out at night. It's not going to happen because then if I let you out at 9:30 at night, well, I need an hour to get back home. And then now it goes to 10:30. I'm not going to do it. Their AA meetings are literally all day, every day. You just have to find it. You have to be creative. That's why we have computers. That's why we have the internets to be able to help you.
Yes, sir.
Thanks.
Thank you, Your Honor.
And we're here now due to Mr. Kabir having a bond violation. This is our third bond violation report that we have had. Our first bond violation. So I guess let me start up. Mr. Kabir is charged with driving while intoxicated. He was ordered as a condition of his bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. State, does he have a DWI open elsewhere to refresh my memory, please? Mr. Salinas, did he not have a DWI?
He currently, yes, Your Honor,
He has an open DWI where?
in Navarro County.
And so we put conditions on him. I can't. Please, Felicia,
The most recent ones, Judge, or there's been a few that we've amended over time.
what are the current conditions now?
The current conditions now are a hearing court every time the case is set on docket, no new law violations. Install a IID device in the vehicle, no driving without permission of the court, no drugs, no alcohol. Plan to obtain a SCRAM device, and to submit to drug and alcohol testing at the court's discretion.
Did he have a curfew as well?
No, Judge.
He originally had a curfew, Your Honor, but because there were no issues with that, we had it removed.
Okay.
Yes.
And so now our first bond violation report that we had was September 23rd, 2024. And in that one, he had been in lockout for failure, I guess, to pay. I don't know, which is weird because we normally always pay for all of them. A second bond violation report was filed January 6th, 2025. Where I guess he was in lockout again because due to no recalibration of the device. And we now, February 4th, 2025, have a third bond. The defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event that occurred on January 16th of 2025 at 11:55 p.m. It was also confirmed by a SCRAM analyst as well. Correct?
Yes, Judge.
Okay, so.
Yes, Your Honor. So, yes, so to begin with the first amended order for pretrial, so if the state wants a copy, I have a copy to show them, but sure. So, Your Honor, just going to the very first order, as Your Honor just noted, usually agency fees are waived for that. However, the box on that for saying that the fees were waived, I believe were not checked on that. Further, Your Honor, the main purpose here for your determination of giving someone bond in the first place is to establish that they come back to court. So are they a flight risk? And then also, are they a danger to the community? Now, Your Honor, if an interlock device is in lockout on a vehicle, it doesn't start. No one's driving that vehicle specifically. There's no way that they can. I can call a witness to testify that, but I know that you
But that doesn't
are aware of
excuse you
that.
from violating the conditions.
Your Honor,
Are you justifying that because of that, you can just,
no, Your Honor, I'm trying to contextualize this because we've been here two prior settings before. I know you've concerned greatly about the number that it's at number 3 now. I'm trying to establish that the first and second, there was no indication of alcohol consumption or drug use during that time.
it wasn't working. How are we supposed to know?
And Your Honor, again, one of the two main points of determining what kind of bond, both the conditions and amount are, will they return to court and community safety? Here, my client who's being, accused of DWI, wasn't driving that vehicle. So it was impossible for him to be driving that vehicle, Your Honor. So I ask you to take that into account as far as public safety goes. As far as this latest bond violation, it's the state's burden to prove that my client violated his bond. All we have right now is a report by SCRAM, but no one is here to testify on behalf of. Well, we can call that, Your Honor, but
Yeah.
sure.
Judge, I spoke with the defense counsel today and he said that he was not requesting to have anybody come here to testify to the SCRAM device.
We have Fleischer that can be called up as a witness to testify as to what happened with and whether he tested positive or not, whether he's consuming alcohol.
It's also the state's burden to prove that he did
So-
that. So that's, yeah.
Please.
Yes, Your Honor, we would call pretrial services, Ms. Felicia Charles.
Okay, ma'am, would you please come up, raise your right hand? Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay.
So you have first amended order and then second, third amended pretrial supervisions and then the board. So referencing the fourth amended order for pretrial supervision and bond conditions, what I'm showing you, do you recognize this? Yes. Can you tell us what this is and what are the conditions that are checked? These are,
Sorry, could you repeat what you just said?
sorry, I said I don't know if she needs that. It was an extra paper.
Okay, I just want it on the record.
Sorry.
That's all right.
Yes, these are pretrial bond conditions, and these are listed as appear in court every time the case is set on docket unless the judge waives appearance. No new law violations, install ignition interlock within the vehicle, no driving without permission of the court, no drugs, no alcohol, and then to obtain. We do have a curfew of 9 p.m. to 6 a.m. and then a SCRAM device to be installed. And so what we're showing you is what's been marked as State's Exhibit 1, and we'll tender this to defense for any objections.
No objections.
Admitted as one.
So in this case regarding the SCRAM device, can you tell us about that?
Yes, so what exactly about?
What is that? What's the standard procedure someone's supposed to do?
Yeah, so a SCRAM device is ordered and it tracks the press.
Objection, Your Honor. The foundation, I believe the state is trying to ask her to testify as far as her, are you trying to establish her as like an expert on SCRAM?
And I was not trying to establish her as an expert, just from her experience, what the SCRAM device is basically for, which she can testify to as a trial.
I'd ask that the court consider that as that testimony as a layperson, not as for the purposes of establishing expertise.
So I want to know whether there's a violation for alcohol consumption. So, what day do we have any kind of hot blows? What's the amount? Do you have anything of that nature?
Yes, so the report should have been provided to the bond violation email as well of the graph.
And I'm showing her now what's marked as State's.
For the exact amounts and everything, I would need to look at the report that was provided in the email.
Okay, please.
Have the graphs been printed? state? Or she's just referring? Yeah, just so we can all agree on what she's referring to.
And I'm showing you what we want to see, it's exhibit 6. Can you please tell us what this is?
So this is a SCRAM report sent back to us whenever the device information and data is pulled. And this is what the analysts observe for either tampers or consumption. And this is what they send us back if there is a confirmed tamper or consumption as per.
Okay, so this fairly accurately depicts in the SCRAM report and that it says this.
Yes,
We will tender defense for any objections and note that this has been, is it correct to say this has been emailed to defense prior to this date?
yes.
Defense received it, no objection, Your Honor.
Okay, it'll be admitted.
Okay, so can you tell us about the specific dates in this report again that was given to defense prior to today of the basic dates that the SCRAM was not completed properly?
Yes, so the device seems to be fully functioning. And on January 17th, Friday, January 17th, the SCRAM device picked up a peak TAC of 0.078%. And then established a zero baseline once again for the dissipation rates of the alcohol at 9:05 a.m. on January 17th.
Say it again.
9:05 a.m. January 17th, 0% TAC was reestablished for the dissipation of alcohol.
Okay, and for those dates, the ones that match on what I'm showing you is TAC Exhibit 2, the bond violation report, can you please, do you recognize this?
Yes.
Can you please read the details of the violations here?
It says the defendant was ordered to obtain a SCRAM device and to refrain from alcohol consumption and not tampering with the device. The defendant's SCRAM device has reported one consumption event. The confirmed alcohol consumption occurred on January 16, 2025 at 11:55 p.m. This information was received on 1/17/2025 and confirmed by a SCRAM analyst.
Thank you, we pass the witness.
Okay.
All right. Good morning. I just want to, if you could turn to, I believe it was the State's Exhibit 3, I think, for the SCRAM non-compliance report, the cover page. Do you see that? Yeah, what she has right there. Oh, is it 6? Okay. Would you stay, since you're close, would you give that to her? Thank you. So just looking at the cover page there, can you read who the agent is on this report?
Justice Turner.
Are you Justice Turner?
Yeah.
Have you consulted with Ms. Turner about this report?
Through the emails, yes, for the bond violation report and the.
What exactly did those conversations include?
The entire.
So
number that was provided.
let me, sorry, that was a poorly phrased question.
I'm sorry,
No,
I don't understand.
that's my fault. Don't worry about it. My question is, did she consult with you when compiling this report?
Would you be more specific?
Did you help in the assembly of this report?
No,
Okay. Have you ever assisted or aided in the assembly of a SCRAM systems non-compliance report?
no, no one.
No, no one in the department does. Okay. And do you have any sort of, have you ever worked for SCRAM systems?
No.
Have you ever had any special training in SCRAM systems?
Yes.
What is that training?
I actually met with Ronald Grant from Sentinel, the regional representative, about maybe 2 months ago
Mhm.
to get an advanced knowledge of this device. This is one of the very few devices that I do have advanced knowledge in, but not expertise.
Sure. And what exactly did this person teach you?
We went
Briefly.
through how to read the graph, kind of how to establish consumption versus a tamper,
Mhm.
environmental factors versus consumption, et cetera.
Okay. So during that training, did you ever actually look at a physical device, the SCRAM device?
No.
So you didn't do any like live experiments where, like, for instance, you put on a SCRAM and then, drank alcohol to see how that works?
No.
No. Okay. And as far as Mr. Kabir's SCRAM device, have you examined it prior to this hearing?
Me personally, no.
Okay. And so, one second. So is it fair to say that you've been thoroughly trained on the theory of SCRAM device and alcohol detection?
What do you
Is that fair to say? That let me rephrase that. So, you don't have any actual technical experience with how the SCRAM device detects alcohol in someone's skin. Is that fair to say?
think?
I don't want you to think. It's a yes or
I
no.
don't understand. I still don't understand.
I'm trying to understand too.
Do I not understand how a SCRAM device works, or have I not for myself? And
Sure. So, this is pretty, is it fair to say like the science is kind of advanced here? Like when you received your training, did you have the personal opinion that that was advanced science that you were learning about?
I believe so.
Okay. And you don't, so basically it sounds like your training, and correct me if I'm wrong here, your training was mostly so you could be able to make sense of what a report says and not necessarily how the actual device itself works. Is that fair to say?
Partially, yes.
Okay. What's what am I partially
We did
wrong
go
about?
over, yes, reading the graphs, but then also what kind of would entail, what would mess with the device.
Okay.
Essentially, as well with tampers, environmental factors with that, makeup
Mhm.
or, placing something between the skin, how things are
Mhm.
worked around with the device, how people evade from, having the correct reading on the device.
Sure. And so that's, you basically learned that all in theory, right? There were no like, withdraw that question. So I'm just saying there was no like actual, you didn't look at any studies. Did you read any studies when you did this? Okay.
I actually met with him due to another case. I wanted to further understand it, so we examined the report for that.
Well,
And also reviewed some of the peer reviewed articles.
Well, that's great. I'm glad that you want to, a lot of people won't. They'll just kind of do their jobs, right? I'm glad that you want to further knowledge, but what I'm trying to get at is it's fair to say that knowing how something works in theory and actually examining the actual thing itself, the practicality of it is different, right? Do you agree with that statement?
Yes.
Okay, so without actually having examined uh, in your own personal observation, how a SCRAM device detects alcohol in someone's system, it seems that, is this fair to say that you're very, very well versed on theory, which is probably more than some other people, but not necessarily on the practicality of detection?
Objection asked and answered.
Okay, just, let's go.
All right. Just answer the question. I don't know if that was an objection or sustained or
Let's just
overruled.
move on. I mean, we're here to see, is there a positive blow or not? She's testifying that
It's
there was.
Sure. I'm just saying that I'll make my argument in closing. I don't have any further questions. Thank you.
Okay, closing, or wait, hold on. Anything further from the witness?
Two very quick questions, Your Honor. So do you get notifications if the SCRAM device has been tampered with?
Yes, we get notified of tampers and consumption events.
And you get notifications if it's been cut off? Like, just what's been going on with the SCRAM device? You get those notifications?
Yes.
Okay, thank you. No further questions.
Matt?
No further questions, Your Honor.
Okay, thank you so much. Okay, argument.
So, Your Honor, this is a pretty basic, simple case. The bond violation report is evidence the defendant was ordered to obtain a SCRAM device and for refraining from alcohol consumption and not tampering with the device. The defendant's SCRAM device was reported on one consumption event. This happened January 16th of this year at 11:55 p.m. And this information was received on January 17th of this year at 5:18 a.m. And clearly, there were up to 4 amended orders for pretrial supervision and bond conditions. It was obvious which the defendant was supposed to do, and he directly violated the order, was evident by the pretrial services and bond violation report. So it's pretty clear here that we would be asking to revoke bonds in this case.
And we would just like to urge that this is a fair and convincing standard, as I already know, Judge, and it's not beyond a reasonable doubt. I don't think that we need a scientist here to prove that the SCRAM device is a device that can be detected.
Okay.
Yeah, Your Honor, I agree with state insofar as this is a simple matter. Where we disagree is, I think a scientist was needed. I think someone who actually has the technical know-how of how this violation report came to be. The state did have that standard of clear and convincing to prove that my client violated this. So far, all we have is a piece of paper that is, at least for right now, is supposed to have been prepared by someone else who is not here to testify. There's no ability to cross-examine them on their expertise, on any notions of false positives, on any issues that a technical expert would actually know about the device. And without that, Your Honor, I think it's very clear that the state failed to prove their burden of proof that my client consumed alcohol. And I would ask that, Your Honor, again, not revoke the bond, keep it as is. My client's here. There hasn't been any warrants for his arrest issued since he's been coming to this court. And in the allegations itself of the underlying offense, there is no allegations of injuries or accident to persons. So again, just take into account that you need to take into consideration flight risk and safety of the community. Nothing that's been established here in this hearing or outside of this hearing should lead the court to believe that my client is a flight risk or a danger to the community. And with that, I'd ask that you not revoke the bond, Your Honor.
And Judge, these devices are used.
Say it again.
These devices are used all the time.
Well, their use all the time
Just
is
so-
irrelevant to needing an expert to testify on that.
Absolutely. I absolutely appreciate your tenacity. I have done everything in my power not to revoke his bond. He is on bond for a DWI in another county. He picked up a DWI here. He's had not one violation. On the first violation, I didn't take him in. He had a second violation. I didn't take him in. Now he has a third violation. It would be unreasonable for me not to. I told you that there was no tolerance in this case. You yet refuse to comply with bond conditions. I find by clear and convincing evidence that you refuse to comply with bond conditions, and I have bent over backwards not to put you into custody. But now we have a positive blow. We have someone who has testified to it, and I believe it. So I am now revoking your bond. He goes with you.
We have the positive THC or stuff.
He had a positive THC, right?
Yeah,
As well?
that we sent him earlier this week.
He also tested positive for
THC.
marijuana as well.
Well, Your Honor,
Here this week.
that wasn't, are we still on the record then on that? Okay. Well, I would also want someone to come testify about that, Your Honor, but you know, that I'll make, I know, but I know you already made your ruling, but I was ready to testify on that because they don't have anything on chain of custody on the test itself, on whether it tests cannabinoids, which delta-8, hemp. There are a bunch of things that are THC related that could pop positive for THC that aren't THC.
Regardless, we admonish him not to put anything in his body that doesn't have any delta whatever. Regardless, it's number 3, goes with you. Molly Lerner.
Yes.
Ma'am, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Judge, on January 30th, 2025, officer ran a check on a vehicle in Harris County, Texas, without proof of financial responsibility. The vehicle also had a defective brake lamp. The traffic stop was initiated. Defendant driver, ID'd by a Texas driver's license, stated she did not have insurance for the vehicle. Officer observed defendant to have thick
Bloodshot eyes or thick slurred speech.
Speech and the odor of marijuana emitting from inside the vehicle.
Officer asked defendant when she last smoked inside the vehicle. Defendant stated she had a few roaches inside the vehicle. Probable cause search was conducted. Officer found 0.103 ounces of marijuana. A DRE officer arrived on scene and conducted Romberg test. Defendant estimated passing of 30 seconds and 12 seconds. Shows D is in an elevated state. DRE also observed thick SS, FSTS conducted 6-6 HGN, 3 out of 8 on walk and turn, 2 out of 4 on one-legged stand. When the defendant was arrested, D repeated the phrase, "Oh my God," several hundred times. Officer knows from ARIDE training that this is a symptom of dissociative anesthetic. The SC read, D refused to sample the breath, blood, search warrant signed and executed.
Okay. Ma'am, I'm going to find that there's probable cause to go forward with the case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
Can you look to see if she has any prior DWIs? Number one. Number two, if she has a valid Texas driver license, please.
No prior DWIs.
Okay, great. Okay. Ms. Lerner, like I said, no alcohol, no drugs. I'm going to randomly test you. Do you have the ability to hire a lawyer or would you like a court-appointed lawyer? Okay, I need you to fill out an application for me. I'll take a look at it. And then for now, I'll also have you sign a receipt with Victoria. I'll later have you get with Fleischer for your bond conditions, and then I'll have you meet with a lawyer.
Her
And
license
being suspended.
I'll let you talk to a lawyer about it. I can't give you legal advice. No, assuming we give you a lawyer, you can ask the lawyer and the lawyer can advise you properly. Just, yeah, talk to the lawyer and they'll be able to advise you properly. I haven't, as long as you have a valid Texas driver license and you have liability insurance, I'm not taking away your privilege to drive. Okay? So, yeah. All right, let me have you get with everybody and then we'll have you speak to someone here momentarily, okay?